Welcome everyone to lecture number 25. Okay, so we have discussed how anyone can possess a citizenship within the India and what exactly that citizenship means as per the Constitution of India. Okay, so now we are going to discuss about how we can lose the citizenship. So loss of citizenship that we are going to discuss it here. Earlier this tab was creating a problem. It was because of the frame rate was very high, so now I have reduced the frame rate, so I won't think there will be an issue in recording the session. Okay, so now proceeding ahead, how we can lose the citizenship. What are the steps, or on in how many ways the citizenship can be lost with respect to the India. Okay, so first is through by the renunciation. First is through the renunciation of citizenship. Renunciation of citizenship. Okay. Another is by termination of citizenship. What are those aspects we are going to discuss in details. Okay. So second is a termination of citizenship. Okay. If a citizen of India voluntarily acquire the citizenship of another country, then it will be the termination. So if a citizen of India voluntarily acquires the citizenship of another. Let us suppose another person has not voluntarily acquired the citizenship of another country. So as soon as the Ministry of Home Affairs got to know that the person is having a citizenship of another country, his citizenship will be terminated at the same point. Okay. Deprivation of citizenship, one is by, another aspect is by the deprivation of citizenship by the government of India. Okay, so in these many ways a person can lost his citizenship. Okay, so let us go in detail to understand how these things work. Okay, first is by renunciation. So a voluntary act by which a person, after acquiring the citizenship of another country, give up her Indian citizenship. Okay, so when a person renounces her Indian citizenship, every minor child of that person also loses its citizenship. So in this the person, in the renunciation also, the person should become voluntarily. Okay, so this renunciation also comes under the voluntary act. So a voluntary act by which a person, after acquiring the citizenship of another country, given up, then it will be and gives up her or his Indian citizenship. Okay, example, who is in such case, if we give example, MF Hussain, who took the citizenship of Qatar. Okay, and renunciated the citizenship of India. Okay, so when a person renounces her Indian citizenship, every minor child of that person also. So when a person re, uh, renounces his Indian citizenship, so that person, minor child, what does it mean minor child? The child who is less than 18 years of age. So minor child of that person also loses the Indian citizenship. That minor child will also lose the Indian citizenship. However, this minor child, when it attains when it attains 18 years of age, then she or he may resume Indian citizenship. Then that child can resume his Indian citizenship once he or she attains age of 18. Okay, so that is through the renunciation. Now another will be your by termination. Okay, by termination. So it takes place by operation of law as soon as a citizen of India voluntarily acquires the citizenship of another country. So in this, the difference between those renunciation and in this termination is like in the renunciation, the person is telling that he is going to take a citizenship of another country and want to renunciate the citizenship of India. So that person will be the citizenship will be revoked. Okay, so it will be taken away. But in the termination case, person has taken a voluntarily acquired the citizenship of another country, but is not informed in that case, so is it terminated. So his citizenship is terminated in that case. So it takes place by law. So this termination takes place by operation of law, by operation of law, as soon as a citizen of India voluntarily acquires the citizenship of another country. See, the main point of focus is that we have to focus that in both the cases, in both the cases, voluntary term is mentioned. Voluntary terms is mentioned. It means that the person himself or herself wanted to take a citizenship of another country. That person is not forcefully has been acquired the citizenship of another country. Okay, in that case only this is viable. So that's why this term voluntary is acquired. Okay, so in the first case, person act by which a person after acquiring citizenship from another country gives up citizenship. In that person willingly tells that after acquiring citizenship from another, he is going to he is going to be away from the Indian citizenship. But in the termination case, he is not renouncing it, he is not informing anyone. So in that case, by a operation of law, as soon as a citizen of India voluntarily acquires the citizenship from another country, his citizenship or her citizenship will be terminated. Okay, okay. So I guess this is pretty much clear. Okay, so let us take an example. You have taken a citizenship from another country and did not renounce the Indian citizenship. His citizenship, that person's citizenship will be terminated as soon as the Ministry of Affairs come to know his citizenship will be terminated. Okay, so see there is a very close meaning between this renunciation and termination. Both have a look. If you read, if you don't read it carefully, it will look both will be similar. Okay, but there is a difference. Here is the termination is happening and its renunciation is happening. Okay, now the third we said was deprivation. By deprivation. Okay, now what does this deprivation means? Okay, first, a compulsory termination of a citizenship that will come under this deprivation. If there is a compulsory termination is declared for any against any person, then it will be come under the deprivation. Okay, deprivation of citizenship by the government of India. It happens by the government of India by themselves. So compulsory termination of citizenship. Okay, now another aspect, on the basis of the order of the central government, on the basis of order of the central government, if the central government has given an order for a particular person that his or his her citizenship will be removed, so by deprivation his citizenship will be removed. Okay, another, if there is a fraud, false representation, false representation, concealment of material. So let us suppose there, as in the previous lecture we have discussed, there are various ways for acquired citizenship of India. Within those things, if it has been found there is a false representation of the papers or any materials or any information is displayed, so that it means that, so in that case by deprivation a citizen or her citizenship will be snatched. Okay, fraud, false representation, concealment of material, concealment of material facts, or 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 being disloyal, or being disloyal to the constitution, or being disloyal to the constitution. Okay, or if that person is out of country, out of country for how many years? For 7 years continuously, for 7 years continuously, in that case also that person's citizenship will be removed. Okay, so in these three ways the citizenship can be removed, loss of citizenship can happen. Okay, now let us proceed for understanding the PIO card scheme. Okay, so that was so before moving ahead I will give you a short introduction that happened with the Citizenship Amendment Act also. Okay, so one second, yeah, so person of Indian origin card scheme, after that also Citizenship Amendment Act happened. Before that we were following that in 2015 we got a Citizenship Amendment Act that has happened in 2015, then 2019 also we have seen. Okay, so we'll discuss all those aspects here. First, PIO card scheme. PIO card scheme. So what does this mean? So any person who at any time held an Indian passport, who at any time, it means like any time in his life he held an Indian passport, if who at any time held an Indian passport, okay, or he or either his or her parents or grandparents or great grandparents or great grandparents was born in India and was permanently resident in India. Okay, if any parents for grandparents or born in India and they were permanent resident in India, then in that case the person will be given as the PIO card scheme, person of Indian origin. Okay, this means person of Indian origin. Okay, so in those cases this PIO card scheme will be eligible. But which are the countries that are not eligible if the people are from those countries? So countries Afghanistan, Bangladesh. Because why these countries? These are the neighboring countries. Why these countries? Because of course there will be the parents or grandparents, the people who are in those countries, but these countries have been formed by the bifurcation of the greater India. Okay, so that's why these countries have been excluded from India: China, Nepal, Pakistan, and Sri Lanka are ineligible. People from these regions are ineligible for PIO card scheme. Okay, the people from these countries are ineligible for the PIO card scheme. The person who is holding this PIO card scheme can visit India. They can visit India without visa for how many years? For 15 years. 15 years. Okay, now there was this PIO card scheme. Okay, now this PIO card scheme is not there, so we'll see what happened to this PIO card scheme. Now we'll see Overseas Citizenship of India, OCI. Overseas Citizen of India. Okay, overseas citizen of India. So in this scheme under the Citizenship Act, this came under the 1955 Citizenship Act. Okay, so now there was since 2015 till 2015 it was applicable. So a foreign national who was eligible to become citizen of India. So on the people who are eligible to become citizen of India will be given as overseas citizen of India on which date? 26 January 1950. Okay, and second, who was a citizen of India on or any time, any time after 26 January 1950. So whoever the people who has a citizenship after 26 January 1950, they will be eligible for OCI card, and who was eligible to become citizen of India on 26 January 1950, they were not citizen of India, but they were eligible to become, but they didn't become citizen of India. Okay, who were eligible to become citizen of India, they can get the OCI card, and person who were the citizen of India on or after 1960 but at anyhow they lost the citizenship, so those people will be given OCI card. Okay, under this OCI card, Pakistan and Bangladesh were not eligible. Okay, they were not eligible, and those people who have a OCI card, they can visit India without visa for life. Okay, without visa for life. So I hope you have understand this PIO card scheme and this OCI card. Okay, in the OCI card, like a person who at any time held the Indian passport, that will be eligible, or whose parents, grandparents, or parents were the permanent resident of India, who was born in India, so those will be eligible for PIO card, and the neighboring countries are not eligible for the PIO. The people from the neighboring countries are not eligible for the PIO card scheme. The countries like Afghanistan, Bangladesh, Bhutan, China, Nepal, Pakistan, Sri Lanka, these are not eligible for a PIO card scheme. Now in the OCI card scheme, the overseas citizenship of India, under this people can visit India without visa for 15 years. Okay. Now in the OCI card scheme, a foreign national who was eligible to become a citizen of India on 26 January 1950, but they didn't take it. So those people can apply for the overseas citizenship of India, or any time the person who had a citizenship up 26 January 1950, but they didn't take, or for any particular reason the citizenship has been removed, so or they lost the citizenship. So in that case, that person will give an oversized citizenship of India, and that person can visit India without visa for life in that case. And the people from this Pakistan and Bangladesh were not eligible for this OCI, overseas citizenship of India. Okay. Now the Citizenship Amendment Act happened. Now Citizenship Amendment Act happened in 2015. Okay. In this Citizenship Amendment Act, both card were merged. And which card? This PIO card. Okay. This PIO card, persons of Indian origin, and this your overseas citizenship of India. Okay. So both card merged and named as overseas citizens of India card holder. Okay. Literally only OCI. Okay. So later in the Citizenship Amendment Act, these were merged into one card called as the overseas citizen of India card holder. In this, both PIO card scheme and OCI card scheme were merged. Okay. Now NRI is an Indian citizen or not? So with respect to the NRI, we'll see what exactly is the law. So with respect to NRI, non-residential Indian, so if they are outside India, they stays, okay, for greater than 182 days, okay, in the financial year, within financial year, okay. So there is a separate income tax defined for them. If they left outside the India more than 182 days, so there will be a separate income tax definition for them, and this 182 days will be counted within the financial year. Financial year starts from this 1st April of the year to next year 31st March. Okay. It should not happen like from the March month of one year to the next in the next financial year they jumped till August. Okay. And then they will be counting 182 days. No, within the same financial year this days should be counted. On that basis this can be done, and NRI can vote and can also become MP. It's only this thing whatever I said, income tax, this only is related to the income tax perspective. Okay. Now so there was one Citizenship Amendment Act happened in 2019. Those things we'll also discuss it here. What was that Citizenship Amendment Act happened? And there was a lots of voice riots happened against this Citizenship Amendment Act 2015. Okay. What this means? Sorry, not 2015. This is 2019. 2019. Okay, so the Citizenship Amendment Bill 2019 has been passed by Parliament with the Rajya Sabha approving on December on December 11, 2019. 125 members supported the legislation by 125 members supported it and 105 opposed it. Okay, so the House also negated the amendments by opposition parties by approving the bill. Okay, now the bill was passed by the Lok Sabha also. This was about the Rajya Sabha. And the bill was passed by the Lok Sabha on December 9, 2019, where 311 members passed it, had voted in the favor, and 80 members opposed it. Okay, so the bill amends the Citizenship Act. So what this bill does? This bill amends the Citizenship Amendment Act of 1955. See, CAA I used to term sometimes Constitutional Amendment Act also, and sometimes Citizenship Amendment Act. So here I am using the term CAA, Citizenship Amendment Act. So it amends the Citizenship Amendment Act of 1955 to make the illegal migrants of 6 communities. So that the illegal migrants of 6 communities from Afghanistan, and we are not going to jump into the religious perspective of it, that why Muslim is not included under it. Okay, so they included the religion, the illegal migrant of 6 communities from Afghanistan, Bangladesh and Pakistan. Afghanistan, Bangladesh and Pakistan was these countries were included. So from these countries illegal migrant can apply for the citizenship. Okay, and the communities, which communities were included under this act? Hindus, Sikhs, Buddhists, Jains and Christians. Okay, and Christians were included. Muslim were not included under it. So due to that, various voices were raised against it, why this is not included under it, and the point by the ruling government was given that Muslim is not included under it because we can't claim that Muslim is an illegal immigrant in these 3 countries, in Afghanistan, in Bangladesh and Pakistan, because these countries were mainly formed on the basis of the religion and they chose the religion Muslim. Okay, that was their verdict. So in those 3 countries we can't claim that the Muslims are the illegal immigrant, but in those 3 countries, if the Hindus perspective, Sikhs, Buddhists, Jains or Christians are living there, as these countries mainly follow Islam, these countries formation were based upon the mainly focused and based upon the religion only. So these religious communities automatically will face difficulties in those regions and will be treated as the illegal immigrants. So in that case India is going to give a shelter to them and give a citizenship to them. Okay, so that was the explanation given by the ruling government. So why they have included those communities and excluded Muslim from this one. Okay, so this bill seeks to relax the requirement of residence in India for citizenship by naturalization from 11 years to 5 years for person belonging to the same 6 religion 3 countries. Okay, so now through this bill, this relax the requirement of residence in India for citizenship by naturalization from. So earlier we had already learned that by naturalization 11 years is requirement, that person has to live within the country, but now this has been relaxed. 5 years for the person belonging in this same religion will be given 5 years. They have to live at least 5 years. By the naturalization they can apply for the citizenship. Okay, make it very important, this is very important. By naturalization we know that 12 years is requirement, and like 12 years, like 1 year, like when you are applying for the registration or by the naturalization, when you are going for it, at that time minimum 11 years should be completed, and at the time of while doing the whole process, that's 12 years there. So it just conclude that 11 years was the year that was given the naturalization. Now it was relaxed to 5 years. Now it was relaxed to 5 years. Who? For those persons who are included under this list. Who are those communities? Hindu, Sikhs, Buddhism, Jains and Christian. For Muslims this is still 11 years, but for Muslims, Sikhs, Buddhism, Jains and Christians it is 5 years. It has been relaxed through the Citizenship Amendment Act. Okay, I hope you have understand it. So the bill seeks to relax. So now these provisions of the bill will not apply on the tribal areas of Assam, Meghalaya, Mizoram, Tripura, included in the 6th schedule of the constitution, as well as the area which are regulated through the inner line permit regime. So which includes with the inner line permit, I have a lecture on that. You can search on my channel, you will get it. Okay, so for the inner line permit regions, those areas will also not be included. So the areas will be like Arunachal Pradesh, Mizoram and Nagaland. These required inner line permit. Okay, so you can't directly go to those regions, you have to require a permit, then you can only visit those regions. So those regions are also excluded from this Citizenship Amendment Act. So the exclusion of the Manipur in the inner line permit was also announced on December 10, 2019. Okay, only those migrants from aforesaid countries will be eligible for Indian citizenship who entered India. So only those migrants from the aforesaid country. Aforesaid country means like the countries that were mentioned: Afghanistan, Bangladesh and Pakistan. Those illegal migrants will be eligible for the citizenship of India who entered into the India by 31st December 2014. Okay, those people who have entered into the India by 31st December 2014 from these countries, from Afghanistan, Bangladesh and Pakistan into the India, those people will only be eligible for the citizenship of the India. Okay, understand? And the president accorded his assent to the bill on 12 December 2019, and CAB now becomes a Citizenship Amendment Act. Okay, the provision of giving citizenship of India as on the basis of citizenship of mother was introduced in 1992 India Citizenship Amendment Act. Okay, so overall the perspective of the Citizenship Act is that first, by the naturalization, getting the citizenship by the naturalization, year has been relaxed from 11 years to 5 years. Not for everyone, for the people, for the illegal migrants who are from these countries, from Afghanistan, Bangladesh and Pakistan. For only those people, for only those communities, these are Hindu, Sikhs, Buddhism, Jains, Christians. For these communities, the citizenship year has been relaxed in the naturalization to 5 years. Okay, and these people, the people who have entered from this Afghanistan, Bangladesh, Pakistan region must be entered into the India by 31st December 2014. After that only they will be eligible to apply for the citizenship of the India. Okay, now we'll give you surrogacy of Indian citizenship. How this surrogacy is, this is a small topic, we'll complete it. Okay, then we'll wrap up. So surrogacy and Indian citizenship. What is deal with the surrogacy and Indian citizenship? What is the connection between that? Okay, now first, German couple, let me give you one story, then you will understand. So the German couple entered into the India and they gave a twin to a birth. The name of the one twin was the Balazs Nicholas. Maybe my spelling will be wrong. Nico Niko. Okay, Balazs Nicholas and Balazs Leonard. Balazs Leonard. Okay, so Germany refused to give a citizenship to them. Germany refused to give a citizenship to both children. Surrogacy is not allowed in the Germany. So at last, after 2 years, long jurisdiction happened in the India. Agreement or talk happened with German, and they were allowed citizenship after that. Okay, so lots of talk happened within after 2 years. They will the children were allowed to give the citizenship. So foreign can't allow citizenship in India in surrogacy. Okay, foreigners can't allow the citizenship in India because India was not giving the citizenship to them. Okay, so what happened, like Germany was telling that okay, we can't give a citizenship to those children who was born by the surrogacy because it is not allowed in the Germany. Okay, now India was also not giving the citizenship to those children, because in India foreigners can't apply for the citizenship if they born their children through surrogacy. Okay, so that's why India helped, and after 2 years long jurisdiction, those two children were given citizenship in the Germany. Okay, so now the surrogacy bill that was passed in the Lok Sabha, that was passed in the Lok Sabha. Uh, so through the surrogacy bill of the India, it's like only the Indians are allowed for the surrogacy. Okay, only the Indians are allowed for the surrogacy in India. Okay, so Surrogacy Act formed in India in 2021, which was earlier passed in law from 2018. So now the Surrogacy Act has been present in the India, and through the Surrogacy Act only Indians are allowed to do for the surrogacy. I hope you have understand this lecture. If you have any doubt, please connect with me on my social media handle. Thank you.